afternoon, folks. We're going to get started with the October 8th, 2019 session of the BMZA. I would ask initially, as always, that you turn off or turn to silent all electronic devices. These proceedings are being recorded by audio and video. If you need to have a discussion, please step out into the hallway to do so. We have a kind of a unique docket today. We have, frankly, two different matters. One is a regular case on our regular docket, which is a matter that was continued, and another matter obviously incorporates a multitude of cases for which we'll hear argument. And so some of the other instructions I normally give, I don't need to give today. So we're going to get started, and we'll call the case of 2019-289, 4122 St. Thomas Avenue. Mr. Thomas Donovan.
Raise your hand, please. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Good afternoon, Mr. Donovan, and welcome back. This is the purpose of your appeal to construct a privacy fence around the perimeter of the property. And we understand, given your presentation previously, that that fence is now up and existing. We had continued the matter to allow you to provide some additional information or evidence surrounding, I guess, maybe when the fence was constructed. I think we've done all of our due diligence that we were able to do here with regard to zoning. We're aware that the heights of the fence normally, for which a variance would not be required, are about 3.5 feet. Your fence is somewhere in the area of 6 to 8 feet around the perimeter of your property, is that correct?
6 foot front, 6 foot back, and then in between, because it's a steep, severe slope. If you want more pictures, they've got more pictures.
Well, why don't you tell us what it is you'd also like to add to the record to supplement based on where we were the last time you were here.
All right. Like I say, it's been put up, and I did submit that latest sketch to the zoning.
That's a new phone, we get to keep that, you're aware of that, right?
Huh?
It's a new rule.
New rule.
So, just to clarify, Mr. Chairman, Mr. Donovan, when you were here in September 10th, there was some discussion about when permits were filed for, which plans accompanied which permit applications, and we did some research into this. When was the fence originally constructed? What date, roughly? And you can do month and year, that's fine.
11/19/18.
Okay. And you did not pull a permit for that fence, correct?
Correct. And then when I went down, explained my story, I didn't know. They allowed me to work up detailed plans, what I did, and also wanted to put a shed up. So I came here for the shed to begin with, thinking that the fence was fine. Then it turns out that the fence wasn't fine, so I submitted another sketch to Fayette Street.
Mm-hmm.
And a number of people worked on it, Charles Lee, Alicia, and Amit Saeed, all, knew all about that. And
So when was this plan submitted?
that was with the shed. That was about the shed, and that wasn't really about the fence.
Okay. And then, when was this plan submitted?
That was submitted. Very recently.
So, Mr. Chairman, and I'll pass this along to the board members so you can see. Mr. Donovan, this plan right here was submitted with your permit for the original fence?
Well, for the shed.
Well, it was submitted for the fence, and I have the permit number right here. So when zoning took a look at this plan, it merely says fence. It doesn't give heights of the fence. So that's why it was missed at the permitting stage. When your new plan was submitted, which does show the heights, at some point later in time, also attached the same permit number, that gives this board a better understanding of where the heights are with respect to the front yard, the side yard, and the rear yard. Now, one point of clarification I did want to find out from you, are there two fences in the front yard, one at the sidewalk level and then one closer to
Yeah.
the front door?
Work on that. Okay. Here we have a front fence with the, this is, you walk up these steps and it shows a severe slope and then more steps. So it's about maybe 12 feet from the sidewalk to my front door. So this is the 6-foot fence and this one's a 7-foot fence. Create some privacy for my taxi cab and people not to rob me.
Okay.
And this happens to be the fence next door, which is also 6 foot. And as you see, that's my side fence.
Okay.
And then here's a picture of the top of my fence, and that's the police helicopter in the sky. That's, they're searching for people all the time in my neighborhood, so I want protection from that.
So, Mr. Chairman and members of the board, I think, unless you have more photographs to submit, Mr. Donovan, I think we have enough for the board to be able to determine the variances required.
And this is the fence across the street. They had their shed broken into last week. And here's a nice back entrance with my address numbers on the fence and everything.
Okay.
With plenty of room for the trash men to get by and everything.
Okay.
This happens to be another house in the neighborhood. They have their fence in their front yard for extra room for their daycare business evidently. And then this is,
But you don't have any records of these properties getting proper permits for these?
I don't know about the property.
Okay.
I just know the neighborhood is dangerous.
Okay.
And here's some protection from Woodley and Belair Road.
Yep,
They
I
put
know the
metal
intersection.
gates up on their businesses, and I'm 2 houses from Belair Road.
Okay.
So they easily come in and smash windows and grab.
All right.
And
I think
they
we have
want
enough on the
numbers.
record, Mr. Chairman, for the board to make its decision at the end of today.
Wait a minute. Oop.
And Mr. Donovan, just confirm for me, you did not at any time put up a fence that was the regulated height, 3.5 feet. Is that right?
Excuse me?
The fence, did you ever have a fence that was just 3.5 feet?
Yes.
And how long was that fence there?
That was there since I've been living there 34 years ago.
Okay.
Eventually, it got a little bit rusty and an eyesore, and all they did was just walk on top of it, because with the hill the way it is, all they have to do is, jump over the fence, and then you running start from the top of the hill and step on top of the fence, and they're out.
Well, have they been doing that for 34 years?
My
You lived there
first,
for 34 years, right?
no, 2013, very bad year for me. They broke into my cab, stole $4,000 in cash.
I heard
I
that.
hate to admit that, but ever since then, they've been smashing my windows, and here's one more piece of evidence. Safely Auto Glass last year, right before I put the fence up. And people protecting their cars, they're putting 9-foot privacy structures up to protect their cars. That's right across the street from my house.
You understand, when you reference all of these other neighbors, they have to stand on their own, and they may have to go through the same process you do. Once it comes to our attention
I know,
that
but I'm
they've been put
explaining
up
my
without
story.
permits. Understand. You said this is a photo of the neighbor?
Yeah, that's 4124,
Is that next door to you?
right next door.
This yellow house?
That's,
This is your house, correct?
yeah, that's my house. It says 4122. That's their house. So if you come down that's their property.
on this side.
Okay. All right.
And then across the street was another, I mean, they really need the protection. And like I say, there's police helicopters all the time. People getting in my yard, throwing trash in there, chasing the basketballs.
Okay. I think we've heard all that,
Of course,
so,
it protected my cab, because that's where I park my cab.
and we've heard that as
It's
well.
It's like having a business almost, and have just right to protect it. So, of course, my personal property is to steal my grills, my gasoline, my tires, everything that they can see.
Okay. Is
Gives
there
me-
anything else you want to submit physically, or that you haven't already told us? Because everything you've said, I think we heard the first time. We were waiting on this additional information with regard to the origination of the fence.
Yeah, just trying to do everything right, because like I say, I've been living in the neighborhood for 34 years.
Okay, now you're starting to repeat again.
Repeat.
I'm asking you, is there anything new?
Well, when I call the police up, I hate to submit it, but they take 45 minutes to show up, and they really don't do anything. I ask them to patrol. I never see police cars coming up and down the alley patrolling my neighborhood.
Okay.
The kids run wild. They run through my yard and do what they want.
That's a
And
repeat.
I call the police.
All right.
I called the police a couple of days ago for my neighbors with too much noise. That only took a half an hour. So, police response time, helicopters.
We didn't have
been
any
through all that.
control over police response time. When the chairman was asking you if there was anything new, it was anything new as it relates to your case and this particular fence. That's it.
By the way, did you submit any police reports?
I called the police
No,
department.
stop. Did you submit to us any
No.
police
I
reports?
just told you what happened. They asked for, they don't keep records. They asked me for CAD numbers, CC numbers. They had very poor documentation, like it was, they don't keep track of it if it's not serious, so. Like I say, I did have called the police many times. They take up forever to show up. They don't write down anything. They just look around and walk away.
Okay.
Thank you very much,
Thanks
sir.
so much for your presentation.
Thank you.
Okay.
Oh, and I spent,
Off the record, sir. We're doing this.
okay,
Sorry.
just in case you need a receipt. But I spent,
Sir, we got off the record in the next meeting. We've got a large, like, wicked clean thing.
Feel free. You can wait till the end of the proceedings, sure. All right, we're going to move on to the next series of matters. Mr. Baumgartner, you want to do the honors and read these numbers into the record?
Sure. So as the chairman did indicate, this is a bit of an unusual appeal. There are quite a few cases on the docket. The property owners are different. They are represented by the same attorney. We have a representative from the law department here as well, representing the interest of the city. What I'm going to do is just very, very briefly read, or very quickly read into the record the case numbers themselves, and there'll be a few preliminary matters that we'll talk about in terms of record keeping, so that the record moving forward is clear. And then, as all of our appeals, the applicant will have the opportunity to go first. The respondent, in this case the city of Baltimore, will have the opportunity to go second, and then the applicant will have a very short rebuttal period, and then that will close the cases. I'm going to read these cases into the record, and then again we'll go through some very brief summary items. All these cases are year 2019, so after 2019 will be the case number. 2019, 289, 145, 321, 146, 147, 325, 148, 149, 326, 150, 317, 151, 304, 152, 307, 153, 327, 154, 322, 155, 319, 156, 309, 157, 324, 173, 314, 175, 174, 176, 313, 177, 312, 196, 305, 197, 308, 198, 310, 199, 311, 200, 315, 201, 316, 202, 318, 203, 323, 204, 328, 205, 329, 206, 332, 286, 337, 306, 333, 334, 335, and 336. Those are all the case numbers. It's my understanding that there are going to be a number of exhibits that will be submitted both by the appellant and then by the city. It's also my understanding that both parties have agreed to stipulate to the admissibility of those exhibits. Is that correct?
Yes, that's correct.
Peter Previs on behalf of all of the appellants, and along with Harry Previs, and that is correct.
Okay. The appellant's exhibits are in front of me. And then the City of Baltimore will be submitting their own exhibits in a paper copy today, is that correct?
Yes, that is.
Okay, great. So they will be, essentially, we have created case files for each individual property, and the case numbers will be consolidated per property address. Every exhibit will then be placed into the corresponding case file moving forward. It's also my understanding, for the benefit of the board, that we have essentially one legal argument that will be applied across the board to all cases, and the parties are free to then argue their case either for or against, with the caveat that there might be a couple outliers, either by property address or by individual facts per property for a couple, not all 64, that the parties can certainly address to the board in their time. Is that a correct summation of?
That is, Mr. Baumgartner. I also want to alert the board that I have some supplemental exhibits. There were 3 leases that didn't get to me at the time that the packets went out. And then I have some copies of bills regarding rezoning that I feel are relevant. And I'm going to call Mr. Kadensky to testify with regard to the status of current bills as well as the ability to try to move these liquor licenses, or businesses, which I believe is a very relevant factor in this case.
Okay. Mr. Chairman, that's all I have preliminarily.
I have a question. This is directed to the city. There are a number of exhibits appended to the respondent's brief, memorandum. Are the exhibits you're intending to submit today the same exhibits, or are they in addition to those that were attached to the memorandum?
Yes, thank you. So the city has attached.
Sorry, ma'am.
Can't hear you.
Just come up and state your name, and then we can
Yes,
respond.
Jane Lewis on behalf of the city of Baltimore. The city has attached to their brief exhibits numbered 1 through 13, and I brought copies of those today. And we have some additional exhibits we'd like to supplement the record with. I've already provided opposing counsel with a copy of those exhibits starting at number 14. And I've also brought copies of those with me today.
And Mr. Chairman, the staff's review of the exhibits from both parties, there's a lot of commonality to them. Some of them are similar or identical, but they will be kept and then included in each case file as appellate's exhibit 1 and then respondent's exhibit 1. So they're going to kind of go in per side, if that clarifies anything.
And for additional clarity, the city's exhibits 1 through 19, the 1 through 13 submitted with the brief, and then the 14 through 19 that will be supplementing are general as to all the properties. And then there are exhibits that are specific to the properties that will be entered starting at number 20. And most of them are 20 through 24 and are essentially identical code enforcement records. Some of the properties have numbers that will go beyond 24 for property-specific submissions. Those will all be submitted to the board as part of the record after today. And those have all also been filed electronically with the board previously.
Very well. Mr. Previs, let me address one issue to you. We understand that there would be some additional testimony. I don't know, Councilwoman Mary Pat Clark, we've agreed that in lieu of a letter that unfortunately didn't make it here, we would allow her to testify on the record as to the contents of that letter since she was the author of it. Is that somehow incorporated into your presentation? If not, I just wanted to make you aware that we have stated to her we would allow her to testify as to the contents of that letter.
Are you asking, do I?
I'm saying, is that part and parcel with your presentation? Are you aware of what I'm talking about? A letter from Councilwoman Mary Pat Clark?
I don't think so. Did I
Okay.
get a copy of that letter?
No, no one has received a copy.
She was Okay.
trying to bring
Okay.
it today, my understanding, and was unable to.
Okay.
Okay. I know why you don't understand what I'm talking about.
Okay.
That is an opposition letter, so you wouldn't be presenting that.
Right.
Very well.
I have no objection other than the general objection that with regard to legislative history, that it is inappropriate for an individual legislator to testify as to what they thought they meant by the bill. I didn't bring any case law with regard to that point, but it is a very clear point. But with regard to matters outside of the intent of the legislative history, then Councilwoman Clark has every right to testify in this hearing.
Well, not knowing what Councilwoman Clark is going to testify about, I think we will allow her to testify, and then we'll make that determination as to whether it's appropriate or not to consider it.
What way to give it?
Exactly.
Thank you. Okay, so I believe the, go ahead and hand them up now.
May
that'd be
I
fine.
give copies of my exhibits to
Yes.
make sure we mop that up now?
Sure.
Thank you.
There's a pre-mark. Good. So.
Just so the record's clear, the presentation of the fact packets that were previously submitted to Mr. Baumgartner, the exhibit numbers were identical in each instance, so there's an exhibit 1 through 7 in each packet that is the same type of document. There was an exhibit 8, which were on some, but mostly not all of the exhibit packets, which were leases, and 3 of those locations did not get their leases to me in time. So at this point, I would like to admit Exhibit 8, 4742 Frederick Avenue, 4101 Norfolk Avenue, and 4300 Falls Road, which are the leases.
Very well.
And I provided copies to council. Additionally, I have copies of the bills and bill history for 4 different properties for which the mayor and city council have passed rezoning of Class A liquor licenses in a residential zone. In addition, when I present testimony through Mr. Kadensky, he has a few pending bills that I did not make sets for everyone, but I can do that. But at this point, I would like to introduce copies of the bill and bill folder for City Council Bill 19-0355. Let's see if I can find the property easy enough on this. 141-145 West Hamburg Street, Council Bill 19-0322. 1818 East Pratt Street, represented by Mr. Kadensky, coincidentally. Council Bill 17-0106, 3601-3605 Park Heights Avenue, and Council Bill 17-0079, 2300 Edmondson Avenue. Copies have been provided to council.
Are you going to have, you indicated Mr. Gudensky will testify.
I'm going to call Mr. Kadensky, and if necessary, or if any of the appellants, I explained to them that this is their appeal, so, but that we've stipulated and admitted all of the evidence, but if there's something that they need to flesh out, or they have an absolute need to testify briefly, that I wouldn't stop them from doing that. I don't think the board would either.
We might, so.
Okay, yeah, but
Give it
basically
time.
what I'm tending to do is streamline this, and so,
Right now, I just need to know who to swear,
okay.
in addition to Mr. Gudensky and perhaps Councilwoman Mary Pat Clark.
Me.
Some real tunes today.
I know.
Guys wanna raise your right hands, please.
I think he's maybe identifying somebody else.
This is the right side.
Raise your right hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Very well. Mr. Rivas, the floor is yours.
Okay, first of all, what I would like to do is provide the board with some clarification as to some of the, some unusual factors as to some of the properties, which I've tried to alert Mr. Baumgartner and Ms. Lewis to, just so that we all understand how this.
Before you start,
Yes, sir.
are any of these unusual factors referenced in your memorandum at all?
Yes.
Okay.
But there's a legal error in my memorandum that I'm going to explain first.
Okay.
And that is, the 18701 indicates that there is a 2-year discontinuance or amortization period for all uses that were previously non-conforming, and a 3-year discontinuance or amortization period for uses that became non-conforming, either by reason of passage of Transform Baltimore or something else. And in my memo, I indicated that a B1 was a lawful use for a liquor store, and it's not. So under the old zoning code, and I've spelled out in Exhibit 7 to each of the memos, we have a cheat sheet here to figure out what the zoning is and what the legislative district is. The very last page of your packet on each individual one. Under the old zoning code, liquor store was a permitted use.
Excuse me, I'm sorry, but
Yes,
do
sir.
we have these exhibits?
Yes. But I think Mr. Previous is going to clarify, there's a 2-year amortization period
Yeah,
for
we're-
certain properties and a 3-year. So I think he's simply clarifying for the record which properties are under.
Subject to which
Correct.
period.
Yes. So under the old zoning code, permitted use for a liquor store was B2, B3, B4, and B5. I mistakenly indicated that B1 was included in that, and I was wrong about that. Under the current zoning code, it's no longer called liquor store, it's called retail goods establishment with alcoholic beverage sales. Another name for liquor store plus. Zoning is a permitted use in a C4, a C5, a TOD4, which I believe is only around the Charles Street area below or by the Charles Theater, and a certain area in Curtis Bay. We only have one licensee in the 46th district who could possibly move their liquor license to that area, so Curtis Bay is kind of out of play anyway. So a non-conforming use under the current zoning code is all of the residentials. It is a conditional use under with a city council ordinance for a C1, C2, or C3. There's also a provision that Mr. Kadensky will explain that any liquor store in other than a C5 would have to be 300 feet away from another liquor store unless there was a zoning board hearing that authorized an exemption for that. So with regard to our list of the 36 properties, and I'd like to explain why there's more than 36 appeals. For many or most of the appellants, we filed an appeal to exercise rights under a conditional use prior to the June 5, 2019 discontinuance, but that date was prior to violation notices being issued by housing. So in an abundance of caution, I refiled appeals for people who received violation notices. So you'll see on the fact sheets, there's 2 case numbers, the one for the violation and one for the conditional use. Now, with regard to there are 2 properties that were previously in a B2, and they are 300 South Highland Avenue and 1800 North Rosedale Street. Do you need me to cross-reference the appeal numbers, Mr. Baumgartner?
Yeah.
South Highlands.
So South Highlands on the first page.
150 and 152.
Yeah.
Thank you, sir. There were 2 other properties that were in a B1, and I may have referenced 1831 Mosher Street in the memo. They are 1241 North Decker Avenue and 1831 Mosher Street that were previously in a B1 zone and are now in an R8 zone. They are not, they were not permitted uses under the old zoning code. So therefore, under the new zoning code, 18701, I forget whether it's A or B, There is a 3-year discontinuance period, which would take it to June 5, 2020 for the previous B2s and not a 2-year.
And then, Mr. Previs, are you withdrawing those from consideration under this batch, or are you proceeding with the understanding that your clients still have the right to operate until that date in 2020?
I'll leave it up to the board of how to decide, but legally what I thought would be appropriate is I'm appealing the violation notice because it was issued early.
Okay.
And I should prevail on that as to the violation notice. I believe that those 2 properties still have standing to assert that they have a non-conforming use, even though, or to challenge zoning code section 18701 as not being legal or constitutional. I don't believe that it is not ripe yet, but if the board so decides, then I understand.
Okay.
There are 2 properties, I'm sorry. So we have the old B2s and we have the old B1s, and everybody else was in an R zone, residential zone. There are 2 properties that, since we started this process, the mayor and city council has purchased the real estate. And they are, and I'm gonna mess myself up. Where's Hugo?
Hugo.
See, I have it by number and not by street name, and I know them by street name. Okay. 900 North Gilmore and 2701 Hugo Avenue. And
The same question. Are you withdrawing those from consideration here today?
I am not, but I fully disclosed in the fact sheets that those properties were purchased, and I do not, I'm not trying to pull any fast ones on anybody, and I'm not trying to represent the mayor and city council as landlord, that they are pursuing this. As with regard to the business owner, they are going forward, but if the board denies on that basis, then I understand.
Okay.
And Mr. Kadensky, did you have in personal, I'm going to call him, I'm just going to ask him real quick. Did you have personal involvement with both of those properties when the city purchased?
I know 2701 Hugo. I'm not sure of 900 North Gilmore. I'm not sure on that one.
Thank you, sir. Okay. So with regard to the mop-up items, that's all that I had. If the board has any questions so far about those items? Then. Okay. All right, next, what I contemplated is I will call Mr. Kadensky as a witness with regard to certain effects of this law has on liquor licensees and their ability to try to move a license, and the current status of certain bills that have been either passed or enacted with regard to rezoning, for one of which is in our list, and the rest that are not. And after that, I was anticipating, well, I'm going to call Miss Virginia Ferguson. She would, not at this point, but she would like to talk to the board a little briefly. And then at that point, after the city's presentation, I would make the closing legal argument. If that's
Very well.
okay. Thank you. All right, I call Mr. Melvin J. Kadensky.
For the record, Melvin J. Cadency, 320 North Charles Street.
And Mr. Kadensky, you were previously sworn?
Yes, I was.
Okay. And what is your profession?
I'm an attorney.
And how long have you been practicing?
Too long, but 1970.
And you're admitted to the Maryland Bar?
I am.
And what are your concentration or areas of practice?
My main concentration is liquor laws, liquor licenses, transfers, and violations.
And does that overlap into the zoning or the use and occupancy permits for those properties?
Yes, it does. When you have to apply for a transfer, you need to get a use and occupancy certificate to be able to have the license transferred.
Okay. Now, you were fully aware of the initial introduction of a bill in 2012 with regard to transfer in Baltimore?
Yes, I am.
But you go back further than that, don't you?
Well, I'm probably one of the, I don't know how old everybody is here, but I go back to the original comprehensive rezoning in 1970, when I'd learned about the rezoning. A fellow named Frank Ashmeyer, who was the head of the zoning at the time, and on that time they were changing Baltimore's code from what was called a prohibitive code, which means if it's all permitted unless it's prohibited, to a permissive. And at that time, a lot of the districts had places that when they changed them to non-conforming uses, they were told that as long as they kept that non-conforming use forever and didn't give it up for a year, they could keep it forever. Well, then came Transform Baltimore, which changed it.
Object to that hearsay testimony about being able to keep your property forever.
Forever, I said.
We heard.
Objecting for the record.
Forever.
Stop.
I did say forever.
Okay. All right.
I think that objection would probably be sustained if I really had that power, but let's say I do. But go ahead.
Oh, I'm going to bring you up to date, and if I get another question, go ahead.
All right. Now, with regard to where we are here today, you've represented many of the appellants in this case with regard to their liquor licenses. Is that correct?
I would say over that period of time up to now, I've probably represented or done transfers somewhere at least a minimum of 1,500 till maybe 2,500. So I'm fairly familiar with all the classes of licenses, and most of the time people don't have a real understanding of the different classes of licenses. They used to only have 2 or 3, an A, and then they created an A2, they created an A7. They don't know the difference between a D, a BD7, Class C. They have WAs, WDs.
Okay, so let's hone in on what we're here for today and what we're not. So today there are no Class BD7 licenses.
Correct.
Is that correct?
Correct.
That battle's for another day.
Correct.
We're here about Class A liquor store licenses and Class A2 liquor store licenses. Is that right?
Correct.
All right. And most people have Class A liquor store licenses.
That's correct.
And what does that allow them to do?
It allows them to be open 6 days and off-premises sales only, no on-premises consumption.
From 6 a.m. to 1
To 12
to
o'clock.
12 a.m. Right?
Mhm.
All right. And then we have this.
There are some that have restrictions on them in the Park Heights, but I mean, the general rule is that.
Okay. And in the Park Heights revitalization area, there are limited hours.
They're
More than that.
Closing 2 hours early, yeah.
Okay. And opening at 9 or 12 or whatever it is.
That's correct.
Okay. Now, A2s. A2s came about in light of the, or either predated or postdated the Court of Appeals decision in Park versus Board of Liquor License Commissioners versus Baltimore City.
That's correct. And
All right.
then,
And what happened there just for historical?
well, they created a license which became a hybrid license where people would be able to convert their licenses from a BD7 or so down to an A2 license, which really was a hybrid license they created at that time. And as a thought remembers me, I think Marvin Mandel was instrumental in getting that law passed.
Okay, and then, so the A2 licenses were in the early 90s, Class BD7 licensees that were operating as taverns had the option to convert that BD7 to a Class A2.
Correct.
And they had 6 days till midnight, is that correct?
That's correct. You
All right.
understand.
And then two of the folks here today have Class A2 licenses, everybody else has Class A's,
That's
right?
correct.
Okay. Now, with regard to how the liquor law works, all right?
Well,
One of the, let me preface my question with, one of the bases for the legal support for the proposition that a amortization or discontinuance period is lawful is that it either gives the business owner sufficient time to recoup its investment or sufficient time to move the license. And can you explain to this board what the possibilities are and what the restrictions would be with regard to trying to transfer any of these Class A or A2 license to a different location? So let's start with, what is the general area that you can move a liquor license to?
Well, general areas, there are 6 legislative districts that were formed, and the law was you can transfer a license within that legislative district only. So you couldn't cross a legislative line and go to another district. So you're limited in those districts to go ahead, whether it's in the 46th or the 45th, you cannot. 45th to the 43rd, you're stuck within that legislative district. Then, for the transfer, the property would have to have proper zoning, which is we're here about.
Let me stay with the districts
Okay.
first as far as liquor law. So now there is something unusual in the liquor code that says that the legislative district that you apply is the 2002 legislative district and not as it existed in 2012?
That's correct. When the legislature, in their wisdom or not wisdom, when they did it, they applied to the 2002 legislative districts.
And those districts they changed a bit to 2012, is
Oh,
that
yes,
right?
some of them are very considerable, but there were 6 districts now in the city. They're down, I think to 5.
Okay. Now, with regard to other possible restrictions in the liquor law, so you testified that if you're in the 46, you can go to anywhere in the 46, is that right?
No, you can't. You can, first of all, you have to go to property that has a zoning and it cannot be within 300 feet of a,
Let's leave zoning aside
Okay.
for a moment.
so you
Just
can't be within 300 feet of a church or school.
Okay, that's one restriction. All right, now, in the 46th district, but I don't think there are any in the other districts except for Midtown, are there any, what we call bullseyes or areas that you can't go into?
Sure, there's Fells Point, Cross Street Market area, a couple other similar areas in wards and precincts in Little Italy, and so forth.
O'Donnell Street?
O'Donnell, there's a whole list of them. There are more exceptions than there are regular ones now.
Okay. Now, with regard to outside the 46th district, we have something called the Midtown area.
Well, you have Midtown Belvedere, and there's a lot of restrictions there about transferring licenses. The only kind of licenses you can get there are Class Bs, which are restaurants.
Okay.
You can't move a license in there.
But the Midtown area from Center Street on the south to 25th Street on the north to
St. Paul and
Guilford.
Howard, yeah.
Guilford on the east and Howard on the west, you cannot move a license into that area, is that correct?
Mhm.
But then, if you're within that area, you can, but you have to be within your legislative district. So
Correct.
that Midtown rectangle is further bisected, is that right?
That's correct.
Okay. Now, you also indicated under the liquor law, you have to be at least how far from a religious institution or an educational institution?
300 feet.
All right. Now, with all that in mind, you have to now look to see whether you can move because of the zoning code, is that right?
That's correct.
All right. So under the new zoning code, permitted use is where?
Would be a C4 or C5 or a TOD4.
Okay, and then there's also an
And place in the-
exemption for Curtis
Curtis
Bay
Bay.
that really doesn't affect any of us here today, right?
Correct.
All right, and then there's a further restriction in the zoning code with regard to if you're in a C4 or a TOD4, you have to be so many feet away from another existing liquor store?
You have to be at least 300 feet away from an existing liquor store.
Okay, but there is a provision that you could ask for
Ask for a
a
waiver.
BMZA appeal for a waiver of that. right?
Correct.
Okay. Now, you have, which I'm going to call Kadensky Exhibit 1. You brought a packet here today with you. Is that right?
That's correct. Legislative districts and zoning overlays.
Okay. And now, the first item in your packet, and Ms. Lewis, I gave you a copy of this.
Come on.
Yeah.
I haven't seen that.
I'm sorry.
Yeah.
The zoning maps are just salad.
I like it. It's nice, isn't it?
It's like a chop salad. Like a salsa. Oh, this is the online thing.
Yeah, they're different sections of the city.
Okay.
Oh,
I've seen the exhibit, so
you're okay. I'm sorry.
I can get a copy of it later. I've taken a look, just clearly maps of what they're purported to be. Thank you.
All right.
You can spend some ink on me.
I'm just starting to like you.
All right, the first item in your packet, which we'll hand up to the board, these are the legislative districts as they existed in 2002?
2002, correct.
Okay, and the 44th is changed the most substantially, is that correct?
That's correct.
Under the old zoning, under the old maps, it encompassed a lot of downtown and over even into Hopkins
That's correct.
Hospital, and it's now further back onto the southwest, is that right?
That's correct.
All right. Now, you've also had the opportunity to pinpoint as best you could where the C4s are, because we all know that the C5 area is downtown and is mostly in the 46th. But what's changed about C4 in relation to B4 under the old zoning code?
Well, B4 and B5 are mainly downtown business districts
Under the old code?
under the old code. So under the new one, they've moved the C4s out further along with the TOD4s.
Okay. So you've done your best to go on the Baltimore City View website.
Correct.
With regard to the current zoning. You can check the box to look up the zoning for a particular area in Baltimore City.
That's correct.
And you've attempted to pinpoint where there are C4s, is that right?
C4s and TOD4s, yes.
Okay, so now if we look at the 40th and Reisterstown Road, are there many C4s that you could move to?
There's one there, and I'm not sure. I think it's this is one.
Looking at what you're looking at?
Yeah, I'm sorry.
Means nothing unless we have
Argument,
something to
Mr.
look at.
Pavas, that there aren't any places for these licenses to move, is that?
Extremely limited.
Very
yes.
limited.
So, in a nutshell, how many, so there are 38, 37?
36.
36 cases here today.
And
How
another,
many available locations are there for moving?
we don't have an exact address, but I was going to have Mr. Kadensky point out that they're extremely limited, and then you would have to try to make a deal with a landlord or purchase a property.
I
So-
understand extremely limited, but it would be helpful if you could.
Yeah.
I think this is compelling testimony, but what would make it super compelling for me would be to understand, like, what, saying extremely limited doesn't, it's
right.
not enough.
Okay.
Like, I need to understand, like, are there 5 locations? Are there 20 locations? Are there not enough locations for all of the licenses? Is that what you're saying?
Right. Mr. Kadensky, let's pinpoint just on Reisterstown Road where there's C4. There are existing liquor licenses on Reisterstown Road already,
Right.
and you would have to be 300 feet away from them.
300 feet away from them, make sure you're within not 300 feet of a church or a school, just to get over that threshold first.
So what is this, what district is this, are you talking about?
The old 40th.
Old 40th. How many of the 36 cases are in the old 40th?
5.
5. Okay.
Okay.
And how many C4, C5, or TOD4 zones are there in the old 40th?
Just that slice of Reisterstown Road,
That's the only place they can move.
only place they can move.
And the testimony is that there's only a couple of locations on that would be appropriate because of location to another liquor
Well-
store, school, or
Right.
church?
Yes.
You can apply to move there, not that you automatically can move there.
No, I
You have to
understand.
meet the criteria of zoning and not be within 300 feet of a church or school.
No, I understand.
Okay.
I'm just trying to get an idea of, I'm trying to whittle it down.
Take it to its lowest common denominator.
Well, yeah, and I really want to understand,
Mhm.
like, what extremely limited actually means.
All right.
Is there another example you have of another district with, what would be helpful is to know, for instance, Old 42nd, we've got 10 people there, and
Right.
this is the only place they can move?
Okay,
And
so-
they're, that,
Yes.
okay.
Gotcha. All right, now, Mr. Kadensky, you see the old 41st?
That's
Which is
correct.
the northwest corner of Baltimore City?
Correct.
And to your knowledge, are there any C4s in there?
I didn't see any when I was looking.
And it's certainly not, there's no C5, it's not part of
No,
downtown?
no, no.
And the TOD4 is down in the Charles Street region, is that right?
How many of the 36 are in the old 41st?
2, 3, 5, 6, 7, 8. 8.
So 8 of the cases here today, there's nowhere for them to move.
Nowhere for them to go, as far as we can tell.
Under the zoning. Good.
So far, we've covered 13 of the 36.
Right.
Okay?
All right, let's go to the 46. We have one person in the 46, 300 North Highland.
That's correct.
All right, the 46 encompasses a lot of downtown C5, is that right?
Correct. Goes from Federal Hill all the way over to past Hollandtown.
Okay, so with regard to 300 North Highland, there are places that he could theoretically move.
He could
with regard
apply to move to it.
Right. Okay.
One of the cases is in the old 46th,
Yes,
Well, it's actually the current 46 still.
current and old.
right. Okay.
Can't make it easy for us.
All right, so we've tackled the 40th, the 41st, and the 46th. Now, the old 44th, of which there are 1, 2, 3, 4, 5, 6, 7, 8, 9 licensees.
9 in the old 44.
Old 44th. Unfortunately for the old 44th, it encompassed a lot of downtown, which was zoned B5 or is currently zoned C5. You would
Correct.
agree with that?
Mhm.
Okay. So
Are there places for the 9 licensees to go, to
the-
move?
under the old 44th, it is conceded that it encompassed much of downtown that's now in the 46th, in which there are currently C5 zones.
Okay.
The only caveat I would give you to that is that downtown has probably the largest places of churches and schools. Every block in that area has either a church or school, whereas in the 46th, they either had a church or a bar. So
Okay.
it's a difference there.
Okay. Now, with regard to the old 45th,
Is it clear in your exhibits where all of the licensees are located, like in the exhibits for each?
in the packets,
Packets.
I provided a color blow-up of the zone.
Addresses and it makes it clear where each, okay.
Yeah, I'll just show you an example. Hopefully this works. So we provided from City View a color.
Mr. Previs and Mr. Kadansky, your testimony is regarding C4 zoning districts, correct? But liquor establishments or retail goods establishments with liquor sales are allowed by conditional use by ordinance in all commercial districts, correct? C1, C2, C3.
With City Council ordinance, yes.
Correct. So it's not that liquor stores can't go in anywhere but C4 and then C5's off the table. It's just that you have to get city council, a city council ordinance to have a liquor store in a C1, C2, or C3. Is that correct?
It's true, except that that won't override the legislative intent of being within 300 feet of a church or school
Sure.
or the other restriction.
But the scope's a bit different as opposed to liquor stores only in C4s versus the ability to do C1, C2, or C3, obviously with the consent of the city council.
Correct.
And the
Ones
mayor.
are permitted uses, ones are conditional, either board or ordinance.
Right, and in this case, they're all ordinance for the retail goods establishment with alcoholic beverage.
Maybe that was intentional.
Maybe so.
I'm going to bite my tongue. Thank you. All right, so just to finish off, Mr. Kadensky, the old 43rd, which, I'm sorry, let's do the 45th first. All right, you don't have any of the C5s downtown?
How many
and-
people are in the old 45th?
I'm sorry. We're doing 45. 1, 2, 3, 4, 5, 6, 7, 8, 9. All right, Mr. Kadensky, you've got some area on Pulaski Highway across from the Gold Club where there's a C4.
Yes, that's correct.
And there's an existing liquor store right there?
There is one right there among other establishments right on Pulaski Highway.
Okay. And to your knowledge, are there any other C4s up on Hartford or Belair Road?
I didn't see any that I would qualify here, no.
Okay. So.
So is it your testimony in the old 45th, there's only one C4 area and that there's already existing, and it's a small area, and there's
It's
already?
within right across the street from an existing liquor store,
Okay.
right down from the Gold Club.
Okay. And now the 43rd, the old 43rd. There are 4 appellants in the old 43rd. All right, now, in that corner of northeast Baltimore, to your knowledge, are there any C4s that would be, there's no C5, right?
No C5,
All right,
and
no TOD4?
no TOD4s, and no,
To your knowledge, are there any C4s up in that corner?
no.
Okay.
So the testimony is with reference to the old 43rd, that there's nowhere at all to move,
Don't believe so.
To apply to move,
to apply to?
Without
I
city
understand
council
that.
ordinance.
yeah, right.
I get it.
And without being 300 feet of a church
Yeah.
school.
Right. Okay. Now,
Have you covered all the locations?
yes,
At issue? I have a question for you. I think you prefaced this whole testimony by suggesting that the analysis of whether or not an amortization is reasonable is whether or not you can find another location to move to? if
I
you have
think,
a liquor
I think there are 2 factors that the legal scholars look to. One is the period, the issue is the period reasonable?
Right.
Which is other legal stuff. But with regard to the logic behind what makes it reasonable is it a period that is long enough to allow the useful life of the use? And the second is, do you give someone enough time to move their business?
Well, doesn't that presuppose that you basically have a right to do that business in perpetuity? I mean, and let me just suggest that your opposition will say, as they've penned in their memorandum, that a liquor license is always at risk of not being able to use it because of changing zoning laws. So you have an expectation, the expectation that you will always be able to utilize a liquor license unchanged. Is that reasonable or unreasonable, given that zoning laws are always changing and that all of these licenses at issue here were purchased after it was determined that a liquor store is a non-conforming use?
I think there's a distinction between a liquor license
Okay,
and a lawful use, zoning use of a liquor store, which under Amrine versus Kotras, and if not reduced by the grant and its progeny with regard to discontinuance, is a vested property right.
okay.
That could be under this license or another license that could be purchased from someone else. Yes, the liquor code does say that a license is not property, but a use is a vested property right. And that's the distinction I would make as to that argument.
Okay.
Okay. Now, Mr. Kadensky, you represented someone with regard to,
1818 East Pratt.
okay. And were you successful in applying for a change of the zoning in that property?
Yes, I was.
Okay, and what was the former zoning prior to Transform Baltimore?
Prior to Transform, it was an R8.
Okay,
Prior to that, it was a commercial use for Prohibition was 1934, since after Prohibition.
okay, and in that instance, that bill has passed and that property has been rezoned?
It has.
And the violation notice as to that property was
It'll be
rescinded?
abated, it'll be abated,
Be
right?
abated, okay. Now, and the 1800 block of Pratt is 2 blocks off of Broadway?
Correct.
And Broadway is
main thoroughfare.
Yeah, and it's commercial, C1E down below, but C2, C3.
Up the upper
up and
part
down,
here.
Okay.
Mhm.
But anything to the east of that is all residential
Correct.
for blocks and blocks and blocks, is that right?
Correct.
Okay, and in that bill, you had the property rezoned to a C1,
That's correct.
and it was just that property,
Just, that was on a corner piece of property, right.
corner piece of property, okay. And what is the existing use for that property?
Well, it's a convenience store with a liquor license,
Okay.
a Class A carryout license.
Now, you've located 3 other bills that have been passed with regard to Class A liquor stores?
One of them I remember is in 3407 Hamilton Avenue.
These were passed up already. Okay. You have,
There's one on Hamburg, and then there's,
you have 1818 East Pratt.
correct,
You have 3601 Park Heights,
yes,
2300 Edmondson Avenue.
and West Hamburg Street.
Okay.
Pardon me, but if the city's willing to stipulate that these bills are these bills for these properties, given the limited time that we have,
Forever.
we ask that we not, sadly, no, we don't have forever. Can,
When you address the body, can you come to the microphones?
They want you
Yes.
to come over here.
here I am. Hi, the city's asking that if we stipulate that these bills are what they purport to be, that we limit testimony,
That's very helpful. Thank you.
reiterating that the bills are the bills. Thank you.
Thank you. And you've also located some pending bills with regard to a change of,
Stipulate to anything pending?
okay.
The city will also stipulate that the pending bills are pending bills.
If I can just read the addresses, 1432 North Chester Street, 1141 Poplar Grove Street. Where'd it go?
Mr. Pravis, the
Yes, sir.
bills, the subject matter of the bills that you're referencing are bills that would allow the existence of a liquor store with regard to a particular location?
The bills are to change the zoning from a residential to a C1 so that the liquor store can remain in existence
Okay,
in spite of Transform Baltimore.
okay.
So you have,
So you're demonstrating a way that that can actually happen, which could happen, a liquor store owner could pursue that for every location that's at issue. Is that correct?
yes, if I can
Go ahead.
examine Mr. Kadensky with regard to that process, I think it would be enlightening. So, I'm sorry, I finished the addresses? 2908 Belmont. You're better at these than I am, Mr. Kadensky.
I'm older than you are.
3500 West Forest Park, which is on our list as a pending bill by other council. 1641 North Bond. And that's it, right?
Correct.
Okay. Apologize I didn't make extra copies. Ms. Lewis, you're okay with me submitting this to the board?
Oh, for the pending bills?
Yeah. And these were everything we could copy off the website.
So the city's fine with the submission, but we'd like to object to the relevance of this testimony. Mr. Previs has already said the legal issue is whether the amortization period is sufficiently reasonable in this case. None of these bills pertain to the appellants in this case. So we're objecting to any of this testimony as irrelevant to the legal issues presented.
Thank you.
Mr. Kadensky, what's the initial process for having a city council pass an ordinance to change the zoning?
Well, first of all, you'd have to get a council person to agree to sponsor an ordinance.
And which council person would that customarily be?
Be the council person in that district where the place is located, the address is located. And once you get that person to sponsor, generally through a lengthy process where they'll meet with the community groups, sit down and explain how long the place has been there, their status in the community, what they've brought to the community, with how the community feels about them. Then it goes to land use, goes to the various other committees, with regard to their getting their approval. There's a sequence of hearings that you go through, and the whole process may take 6 to 8, or maybe 9 months, and it's not easy to get somebody to sponsor that sort of bill, and for it to go all the way through.
Okay, if the council person whose district that the property is in objects to that, as a practical matter, is that bill going anywhere?
No, because they have councilmanic courtesy. They won't take another council person putting a bill in.
Okay, so we have 4 properties that have been out of the 7. How many properties were going to be rezoned prior to Transform Baltimore passing in
was
December
around-
5th, 16?
Around 75, I think, give or take.
After it passed, it was 75.
You're right, correct.
Do you remember the original War Memorial meeting, Planning Commission meeting, where they passed out a list and sent letters?
I think it was probably not 25 or 30 more on that list,
About 120 something?
something like that, correct.
Okay, and some of these places have closed up.
Some have closed up, some the city has bought and gave them, they're actually, ironically, the city bought the property, gave them relocation money to relocate when they knew they couldn't relocate to any place that would fit into Transform Baltimore.
Okay. So after Transform, we have about 74, 75 Class A and Class A2 licenses.
Approximately,
That are being told to discontinue on June 5th, 2019, right?
correct.
Okay. Now, out of that, we have 4 and another pending 8 or so who are requesting rezoning?
That's correct.
Okay. All right, now. One second, I think that's it. Okay. Thank you, Mr. Kadensky. I have no further questions for you. Ms. Lewis may have questions, the board may have questions.
I'm going to move over for you.
Well, thank you.
I'm going to back up.
Jane Lewis for the city. So you showed us some maps earlier that we were looking at. Can you show me those color maps again with the zoning?
There you go.
Oh, I'm sorry.
Thank you. There's no extra color copy. The board can spare them. So these maps that you've submitted, do these show churches or schools on the maps?
They do not. You'd have to get a specific address to go. As I spent it downtown, there's a church, at least 1 or 2 every block. And
And in these maps, they show that in all of the zones, there are commercially zoned areas. Is that correct?
when you say commercial, you mean commercially for a liquor license or just commercially?
Commercial zones beginning with C.
There are some Cs in there, right?
And it is possible, according to your testimony, for liquor stores to locate in zones beginning with C, given certain conditions or steps that takes place. It is possible for liquor stores to locate in
Possible.
commercial zones. Just,
the two-
it is not impossible
Not
for them to.
impossible, no.
That's all. So it is not impossible for any of the appellants in this case to find locations. Not theoretically impossible for them to relocate.
Very improbable.
But not impossible.
Not impossible.
And you said that as part of a relocation, a liquor store owner would have to approach a landlord in one of the areas where they could potentially relocate. To your knowledge, did any of these appellants do that?
I don't, either they approach a landlord or they can buy the property.
Okay, to your knowledge.
Not that I know of.
Okay. Is it also possible for the owner of a liquor license to find an existing business who may want to use that liquor license for a place where they're already located?
Where there's an existing license?
No, where there's an existing business.
If there's
Who is
existing,
in an area that's, let me clarify, if there's a business in an area where it's permitted to have a liquor license, a Class A liquor license, either with city council approval or not, in one of these council areas, is it possible for someone who owns a liquor license, in the way these appellants do, to find a business that doesn't have a liquor license and negotiate to transfer their liquor license to that other business? Is that possible?
If it qualifies for the retail business with a C1, with a conditional use ordinance, or it's not within 300 feet of a church or school, or 300 feet of another liquor establishment.
Right, but with all those conditions applying, it's possible to find another business to take over that liquor license,
Tough road,
but it's possible.
possible.
And to your knowledge, did any of the appellants in this case,
Not that I know, not the ones I represent.
how many of the appellants in this case do you represent?
Maybe 15,
Okay.
20.
If I show you a list, this is the city's Exhibit 14 that we submitted. It's a list of the properties. Sorry, I don't have. Can you identify on this list which of these clients you represented?
Mr. Sabatu on Federal Street.
You can check them off.
Excuse me, counsel, what's the relevance?
This is just a summary sheet showing all this
No, I
stores.
understand that, I'm just, what's the relevance of which ones he represents?
I think it'll become clear with my following questions.
One on Holland Avenue, he had come to me, I referred to the Mr. Previs. He used to have an office right there at 412 South Holland Avenue. S&T Market. It's Norfolk Avenue. $4742 Frederick Avenue. $4,001 Edmondson. Falls Road, 4300. 1501 North Fulton. 300 North Gilmore. 1642 North Wolf Street, 742 North Fulton, 3600 West Garrison, 2701 Hugo, that was the one the city acquired.
And that's the end of the pages. Did you represent these clients?
I think 900 North Gilmore, yeah.
Did you represent the clients that you listed when they were in the process of acquiring their liquor businesses?
Some I did and some I didn't.
And some of the clients that you represented acquired their businesses after the Transform Law, Section 18701, was enacted. Is that correct?
They might have.
Well, according to this, when you see the date of the liquor license transfer, a number of them did. Let's look at Harvey Macklin.
Yeah, I just referred him. I didn't do the settlement on that.
Okay. What about Grow LLC, Sulachna Acharya, operating at 4742 Frederick
That
Avenue?
contract was done by Charlie Sung in Howard County.
What about Vishwakarma Group, 4300 Falls Road?
He had that license before, and that was when they married Pat, and they got a agreement with him on.
Have you ever represented any clients who acquired a liquor business after the Transform Law was enacted?
I'm not sure. Some of them, maybe one or two, but they were disclosures to them. There was a possible problem.
You disclosed to them there's a possible problem. When you say a possible problem, you mean the law would prohibit their sale of alcohol after
They would.
June 2019?
No, that's not true. They could still sell alcohol. Their use would expire. There's a difference between having a valid license and having a valid use.
Okay. So when I said the possible problem is that they would not be allowed to sell alcohol
Or
after
use the
July
property for
2019.
the sale of alcohol.
Okay,
They would not lose their license.
okay. And you advised them of that.
The ones that
Have you ever had any,
Are you asking Mr. Kadinsky about his privileged conversations with his clients?
I didn't, he volunteered that he disclosed that there was a problem.
Is the relevancy coming?
Yes, I believe it's relevant in the sense that appellants are arguing that this was not enough time for them to wind down their businesses and that the 2-year period is unreasonable. Many of the appellants on this list acquired their businesses after the law was already enacted and should have and probably were aware of the law.
I'm aware of that. I read your memo.
Mhm.
Okay,
So that's the relevance of these questions,
Okay.
but I can move on.
great.
Have you ever advised any clients who acquired their liquor businesses after the Transform Law was introduced in 2012?
I don't remember right now, no.
But you represented over 1,500 clients?
1,500, before Transform Baltimore.
And after Transform Baltimore, approximately how many clients have you represented?
In the liquor business, probably somewhere between 30 and 40 a year.
Okay. And some of those may have been people who acquired their businesses after
Some may,
Transform.
some were new licenses.
And you testified that you were aware of the Transform law.
Knew
when
that
it
was going through the.
Knew it was
yeah.
going through in 2012. Okay, I have no further questions. Thank you.
I have no rebuttal.
I have a quick question. What's the value of an A1 or an A2 license? Like, if you try to sell it to someone who, let's say that I had a spot that it could move to, how much does it cost?
Depends on what area of the town you are and where you can move it to.
Okay.
And there's, just take a different
Give me
class of
an average.
maybe 35,000, 40,000. Assuming somebody wants to buy it and it has a place for it, right?
Let's say that I don't have I'm not gonna buy one and I wanna create one. And I
Cannot-
found a location.
Can't create one.
You can't, there,
Only license you can create in the city are Bs, restaurant licenses, which have a certain qualification for capital investment, seating, and so forth. No other ones.
last question. How many liquor stores exist in Baltimore City, licenses, do you know?
You know, that's probably a really good question, but you've got representatives of the liquor board here, they could tell you.
How many, I'm just curious how many liquor licenses, A1 or A2, exist in Baltimore City?
I don't have that number.
Okay. Okay.
If I can speak, I know that I've seen in the last list that they number the licenses, and I've seen A146.
146
Th-
liquor stores in the city?
I know that from the last year, I've seen a 146. It may be more,
Wow,
but they number
okay.
accordingly. So I don't know the exact number. I don't know if representatives from the board would have that off the top of their head, but we could check the board's database, but I don't have that figure.
When you're saying 146, is that the number of actual liquor stores or number of licenses for?
Should be same thing.
Same thing.
Should be
Okay.
same thing. I don't think there's more than 2, 3 Class A2s.
Okay.
Okay.
The rest of them are Class A.
A,
Some of them are beer and wine. Most are beer, wine, liquor.
Okay.
And we have a new animal called an A7 that I don't know if anybody's gone through completion for that yet. But in response to Transform Baltimore with regard to the limitation on the BD7 licenses, there was a provision placed in the law, in the state liquor law, to allow BD7s in certain circumstances to convert to an A7. Again, you have the same zoning restrictions, so that's been problematic, but that's not for today, that's for another day.
Yes. Cities also like to object to any testimony from Mr. Kadensky regarding the value of the liquor licenses, as he's not qualified as an expert on the economic value of these licenses.
I just wanted to know from his personal experience.
Would you like me to qualify them?
No.
I think we all know what Mr. Kadinsky does for a living.
Thank you, Mr. Kudensky. I appreciate your help. I'm going to very briefly call Ms. Virginia Ferguson.
She asked.
Good afternoon.
Good afternoon.
Ms. Ferguson, you were previously sworn?
Yes,
Okay, and what is your business address?
1831 Mosier Street.
And what's the name of your business?
Jamella's Package Goods Store.
And that's on the corner of Mosher and what?
Mosier and Landville? Monroe. Monroe,
Okay,
I'm sorry.
Sorry about that. All right, and where, do you live close by to the liquor store?
Not far.
Not far? Okay.
Wait a minute, my husband lives nearby to the liquor store.
All right. And how long have you owned that liquor store?
More than 30 years, I think 32 years.
Okay, and you bought the business, the property, the real estate and the business?
Yes.
32 years?
Mhm.
Okay. And you were previously zoned in a B1 business zone, so is that correct?
Yes.
Okay. Did you recall ever getting any kind of notice back years prior about you might have to shut down your liquor store?
Not until recently.
When did you find out?
I think about a little more than a year ago.
Okay. All right. And you run a nice place?
Yes.
Any trouble?
Never had any problems.
You know the neighbors?
Yes.
Neighbors respect you?
Yes.
Okay. And do you sell just alcohol, or do you sell other items as well?
It's like things they might need.
Okay.
Snacks, paper towels, toilet paper, sodas, candies, things like that.
Okay. Would you like to stay?
Yes.
Thank you, ma'am. I have no further questions.
I have a couple of questions for this witness. You said you got notice about a year ago about your liquor license or your store may
Yes.
might have to close. How did you get that notice? Where'd you get it from?
Through certified mail.
Did any representative of the city previously visit your, so you did not receive any other notice in or about January of 2018 regarding this law that had come into effect?
Yes. You said 2018? Yes.
Well, January 2018 is what I said.
Okay. Well, 2018.
Okay, would that be fair? Could it have been January in 2018?
Yes.
Okay. And what, if any, efforts did you undertake to look for a new place or consider a possible relocation of your store, if at all,
None.
since getting that notice?
None, because I wasn't really aware that we could move the business. I wasn't aware of that. And then there is no place really to move the business to.
Have you looked into other places to move the business to?
No, I have not.
And how do you know there's no place to move the business to?
I was under the assumption that you could not move a liquor license but so far. Am I right?
That's the old rule.
Okay, well,
It's
I'm
now
an
within-
old lady, so that's, I'm 73 years old, so that was, when we went into business, that was the law.
That's right. It used to be a 1 mile limitation without legislative districts.
So
Back
you
in the
weren't
70s.
aware at the time the law changed in 2017, which provided for this 2-year period?
No.
You didn't know that?
And I'm just gonna jump in, Ms. Ferguson, you said that you received a certified letter in the mail informing you about the law change, is that right?
Yes.
So did anyone from the city actually come to your store and ask you what your plans were?
No,
No one visited you at all?
no one.
Do you work in the store?
My son works in the store, and had someone come, he would have surely told me, because I usually take care of all of the business.
Okay.
Thank you, ma'am.
You done?
Yes, ma'am. I have-
Ms. Lewis, do you have any questions? Thank you. I have no further witnesses.
Mr. Previs,
Yes, sir.
do you have any, other than what's referenced in your legal memorandum, do you have any other legal authority for your proposition that the use of a liquor license, and we, I think, distinguished the physicality of having a liquor license and then being able to use that liquor license, the use of a liquor license is a property right that vests in the owner?
I would cite you to Amrine versus Kotras, which is in the memo,
Okay.
which stands for the proposition that a lawful use of a property is a vested property right. That was modified. Myself and former Judge Barnes of the Court of Appeals, that was not the right way to go, but the use of the property, for example, if you have an adult entertainment, and you could look at, I cite you the case of Dembo versus zoning board, where they made the distinction that the use of the property, which in that case was non-conforming and grandfathered, was a whole different animal than the licensing for the adult entertainment license. And the Court of Special Appeals actually chastised the mayor and city council for mixing those two concepts together and said, one is the lawful use of the property, and that goes with the building, and the other is the actual licensing. So if you have the Gold Club in that case that was grandfathered in for lawful non-conforming use of adult entertainment, that case stood for the proposition as the fact that they did not apply for the license within the 6 months of the ordinance didn't mean they lost their use of the property. They still had adult entertainment. But they had to go get an adult entertainment license, which is now administered by the liquor board. It used to be by the zoning administrator.
But that wasn't a case in which there was an amortization applied to the
No,
succession
sir.
of that use.
But as I'm thinking as I'm speaking, and I would cite you the case of Dembo that says there's a difference between your zoning and your lawful non-conforming use of vested property right in the licensing. So a new licensee could come in and mess up and have that adult entertainment license revoked, but there's still a lawful non-conforming use for the property, and a new licensee could qualify to obtain an adult entertainment license. Same thing with a liquor license. If
Okay,
you
so as part of your presentation, let's say in year one, you have a certain set of circumstances with regard to the public's reaction or the impact on the public of the use of that lawful use, adult entertainment. And then a number of things occur in which, information and testimony is provided to a city government that says this is impacting the public in a negative way. Is it your proposition or position that a city can then not change the zoning law that would impact and in fact do away with what may be a lawful use but a non-conforming use in the future? Because in fact, aren't non-conforming uses designed to eventually go away? Isn't that why they're non-conforming?
Yes, as long as they are done so constitutionally without a taking, I would agree. So let me just,
Okay, so you understand my
I do.
question and how it relates to this situation?
Right.
In which my understanding of the record is there was, despite at least your one witness saying she wasn't aware of the change in the law until a year ago, that this was on the books for quite a while in terms of the enactment or potential enactment of legislation, lots of hearings, lots of testimony, including lots of testimony from experts with regard and citizens with regard to the impact of liquor stores on the public generally, which all of the appellants were entitled to participate in and say, not my store, not this area, to refute or rebut that evidence. Did any of that occur with regard to these appellants, if you know?
Did what occur,
With
Mr. Chairman? I'm
to-
sorry.
When the presentation which gave the city council the testimony, which they then considered and then sought to enact legislation to create this law that was enacted in 2017, you would agree that everybody who had an interest had certainly a right, if not an obligation, to be present to be heard by the city council with regard to what that potential impact was going to be of the legislation, right?
Correct.
Did your clients take advantage of that opportunity to present any of the issues of, how it's going to negatively impact us, or that the basis for which you're enacting this law, the promotion of the public interest because of violence and crime, we reject that proposition because we have evidence over here that says that's not happening. Did that occur?
Yes. But as Mr. Kadensky pointed out, you started out with a list of about 120-some
Yes, sir.
affected licensees.
Yes, sir.
And by the time the law got passed, it went down to 74, I believe it is. Which
Okay.
means that there's some attrition, but for the most part, you have a situation where prior to transform, it was open season with regard to requesting a change in your zoning. And the people that knew about that and had a relationship with their council person were able to get an amendment to the initial list to get off of that list. And they're not here today, thank goodness for them.
Well, tell me, what's the timeline? How long did it take, if you know, from the time a liquor license owner or somebody who operates a liquor store wants to go the route of getting an ordinance with regard to their particular location? What is that, how long does that take from start to finish?
To request an ordinance to change the zoning?
Right.
So with regard to the transform, let me just back up a second to that. That was just a matter of numerous amendments to the actual list that passed. It was initially a 2012 bill that ended up being a 2016 bill that was passed.
Okay.
But after that, then to request a change in your zoning, and Mr. Baumgartner's written several letters in all these bills saying we defer to the planning commission and we find that this is inappropriate. But in any event, the timing for that would be probably 6 to 9 months, and I believe Mr. Kadensky said 9
Okay.
months.
So that when the law was enacted in, whenever it was in 2017, if you began the process of seeking that alternative avenue, that would be a 6 to 9 month process, which would have concluded prior to the 2019 end date, right?
Correct.
Okay.
And it's kind of embarrassing to the city that that's what is going on here. Because if you have if you're giving a favor, then you're going to get a new bill passed. And if you're not giving a favor, you're not going to get a new bill passed. And I apologize to the good people in city government, but honestly, to honestly answer your question, that's what we have here. This bill was not properly thought through, affected a lot of innocent people like Ms. Ferguson over here.
Well, is there a reasonable, is it your position that there would never be a reasonable period, amortization time, to enact this law?
I indicated in my memorandum, when I first started reading this law, I kept going on and on and on, and I'd have to be the dumbest lawyer there is because I just don't understand this. The more I read it, the more I don't understand. And I initially read the Grant case and the Harris case and the other cases in Maryland that said amortization is okay. But finally, having gone outside of Maryland, realized I don't agree with that anymore. And certainly, if I were here to ask this board to reverse the Supreme Court on the issue of abortion, then this, not that that's appropriate issue for this board, but the board would say, well, I have to defer to the judicial precedent of the Supreme Court. And in this case, I would think that the board, although I would want them to exercise their own independent legal knowledge and experience and say that, yeah, the Maryland Court of Appeals was wrong in Grant. A taking is a taking is a taking. So I'm arguing that, but I understand that this board will probably say we are constrained to precedent, which says a reasonable amortization period is appropriate.
And it says that in Maryland.
And it
right?
says that in Maryland. And I'm saying Maryland should change.
Okay.
But I'm not expecting that to happen today. It would be nice, but I'm not expecting it. But I'm not prepared to concede that issue for two reasons. One is having read the from cases from other states and looking at what Pennsylvania did and said, this is just wrong. So
Well,
it's
it's
a taking, and B, it's just nonsensical.
Well, you acknowledge that specifically with regard to Pennsylvania, they're
Right.
operating under a different construct because their state constitution precludes amortizations like this, right?
Even if it didn't
Missouri,
preclude-
Ohio, and Pennsylvania have a different view of this kind of law.
as should Maryland.
47
Because it's basically a taking issue, which is either the U.S. and or the Maryland Declaration of Rights. I've read it, I try to understand it, and I'm just too stupid to understand it, and I'm thinking, well, maybe it's not that I'm so stupid, maybe this just doesn't make sense. And the cases are saying, well, you can restrict something in the future, so why can't you restrict it now or sometime in the future? I just don't understand it. So the first part is Maryland should change and say amortization is a taking. Amortization, the standard is nonsensical, so we really don't know how to apply it. But secondly, if applying precedent of the Harris case, of the Grant case and the Harris case and their progeny, under these set of circumstances, in light of the fact that, for example, the depreciation or amortization that would be looked at by the tax code would say that a liquor license is depreciable after 15 years, that had to come from somewhere. That had to have some logic of how long a business should allow to last, and a building of 39 years. Now, the city would argue, I guess I'm going into argument, which is fantastic. The city would argue, well, there's a second floor to these buildings. But look at the photographs of where these properties are, and they are the most valuable thing in the area. And I would also point out, I'm not speaking ill of the folks in these areas. The way I see it, Ms. Ferguson, family lives on the block. It may look rough in that area, but they are tight, and they have a nice area, and the people come, and they enjoy that store. And if you have a couple bad apples that hang out and cause a trouble and try to sell drugs, doesn't mean that the neighborhood's bad. It's the exact opposite. They're affecting the neighborhood. It doesn't mean that the licensee is bad. They're putting up with the same thing as everybody else. So Hopkins studies this. If you have this, it's nonsensical. You could take a liquor store in a low-income area. You could replace it with a barber shop, a bail bond business. You're going to get the same result. Correlation does not carry the day. There has to be some type of causation. And it's not it. So after the Freddie Gray riots, throw all that out the window. We now have people who are dealing with neighborhoods where there are loiterers in front of the business, and the police saying, under this consent order, we can't tell them to leave. We can't do anything, which is not the law, but is the fear of the police department. And if the city were really serious about tackling the problems with bad eggs at liquor stores or convenience stores, because I don't think it makes a difference. I represent convenience stores without liquor licenses, and they have the same exact issues. If you really wanted to tackle that issue, you send police in undercover and you get rid of the bad eggs, and you leave the business owners and their neighbors, their customers, to live peacefully. That's my 2 cents. And after having represented so many of these folks and being blamed that they are the bad operators, I can't say that I've ever not represented a bad operator. I have on a couple occasions. But for the most part, these folks are sincere about wanting to run their business peacefully, help their neighbors, make a couple dollars while they're doing it, and exist.
Mr. Previs, of these properties, do any of the owners or operators, did they acquire their interest in the property prior to 1971?
Yes. Mr. Charles White, are you here, Mr. White? Mr. Charles White purchased his property from a Jewish American fellow in 1960. Actually, he bought the business in 1968 and was able to come up with the money to buy his building in 1976. And he's been there. How old are you, Mr. White? Yes, sir.
79.
79 years old.
What
He's
was that
operated
property address?
421? Is that the business address?
Yes.
406 East 21st Street.
Sorry, that was 406 East 21st?
21st Street. He's just north of North Avenue and just west of Green Mount. And would like to die with his boots on.
So his property would have become non-conforming under the 1971 code. Were there any other properties that were acquired prior to the 1971 code? And where
From
I'm
the
going with this,
current owners?
correct.
No, I think Ms. Mayfield purchased her property in 1976.
So when they acquired their interest in
The
the
real
property, either via use or via the real estate, that was acquired under the presumed knowledge that they were a lawful non-conforming use.
Yes.
And the law in Maryland on non-conforming uses is that they eventually go away, correct? I mean, isn't that what a non-conforming
Under legal
use
means,
is?
I would agree with that, yes.
Okay.
I would say, yes, they eventually go away, but not to the exclusion of a vested property right. And I wouldn't agree with you that if you purchased a business or bought a property that had a lawful non-conforming use, that is with the expectation that the city is going to pass an ordinance saying that must discontinue. There's interesting language that I cited from the Pennsylvania case that indicates, how far do we take this? We're saying that amortization is appropriate. Do we apply amortization to people's residences who are rezoned to a commercial zone and they have 2 years to have to leave their house?
Would you,
You had some testimony regarding the Transform Baltimore process, which was comprehensive rezoning. How many years did that process unfold, if you know?
Ms. Lewis provided a sign-in sheet for a meeting which I saw my name on in 2012.
Okay.
And
So
that
if,
was when I first started getting,
so if the comprehensive rezoning, which was going through the entire city, changing zoning districts, altering the zoning code, if that took 5 or 6 years to develop in hundreds of meetings with different folks, were there liquor stores that were rezoned as a result of that process into zoning districts in which their business could continue, if you know?
yes, about 50.
So through a 5-year period, there was a public process in which any resident of Baltimore who owned a business or not could be involved in the process over that long period of time to protect their legal interest in their property. And they would have had to afford themselves of that during that 5 or 6 year process.
And have the relation with the council person to make that happen, yes.
Okay.
Well, do you know if the 36 that you represent, if they participated in that process? How many of them did?
In the process of
From 2012?
fighting
when- Yeah.
the provisions in Transform Baltimore that said that there's a discontinuance of liquor stores and there's a discontinuance of Class BD7 licenses that don't do a majority of sale to drink here liquor as opposed to carry out liquor. Absolutely, there were people that were fighting hard.
How many
K-Grow,
of these 36 participated in that process?
I can guess for you. Oops.
you know what, while you're looking at that, Mr. Previs, I'm
Yes, sir.
looking at your memorandum, and there's a provision on, or a section on page 8, where after you cite the Pennsylvania case and Pennsylvania law, which we know has a prohibition in its state constitution against these kinds of amortization laws, it says, and you've stated here today, Maryland should follow Pennsylvania. Maryland should follow Pennsylvania in that it has long been held that a non-conforming use is a vested property right and entitled to constitutional protection. So by virtue of you asking that Maryland should follow Pennsylvania, you're acknowledging that Maryland doesn't follow Pennsylvania presently, right?
Absolutely.
Okay.
Yeah.
Thanks.
I'm saying that the first case that came out, Amrine versus Cotrus, held for the proposition that a lawful use is a vested property right. And then you have the Grant case that says, but it is okay to allow that use to discontinue without eminent domain and a paying for a taking,
Okay. Okay.
which I logically disagree. Looking through the list, it's probably about half that participated. The KGRO, the Korean American Grocers Association, was actively involved in that process, hired a lobbyist, probably had some council votes at some point, and then the riots hit, and the organization, not the organization, but the momentum kind of disappeared, and it ended up being a unanimous vote, which was somewhat unfortunate. But you'll see Ms. Lewis's list, she listed chronologically, and you'll see that between 2008 and 2012, which would have given those people a 2-year bonus, there are none. And then you have a bunch of sales past 2012, and I believe what's occurring there in a lot of instances is people that were involved sold their businesses. And we were talking about looking through the liquor board cards. You can learn a lot about the history of Baltimore, and going through those cards that go back to 1934 and looking at the names and the people that own the particular businesses. And you see a lot of early on pharmacies with liquors, Jewish American folks, Italian American folks, and later African American folks buying those businesses. And then the Korean Americans come in. And most recently, what I see on these lists is we have Ethiopians and Eritreans, Latino Americans, and African Americans again coming in and buying these businesses. Unfortunately, there's a lot of sales that happened after 2012 that the sellers knew, buyers didn't. So you have one group of people that have owned their businesses for years, and then you have another group, oh, I spent $90,000. Oops. Should I think I hit most of everything, but just to kind of outline, you read my argument. The first argument I said is I think that grant should be overturned. The second argument is that 2 years just doesn't cut it under any circumstances for a lawful business such as this. Bless you.
Excuse me, thank you.
I acknowledge that it is the appellant's burden of proof on that issue. I also point the board to the fact that the IRS would provide at least 15 years. I would note that this board does not have the discretion to say, well, that's unfair, let's give them 3 years, or let's give them 4 years. It's either 2 years is good or the law's no good. Even a court would not have the power to amend what the mayor and city council did. You would say it's not good, send it back, do another law. 15 years is what I believe is a minimum. You see in a lot of decisions that they kind of kick the can down the road by saying, well, this is dragged on so long, it's now at 10 years or 15 years. That's good enough. But really, that's not the standard. 2 years is not sufficient. We provided evidence that it's virtually impossible to move 75 licenses to the limited areas. It's not realistic to believe that you're going to get city council ordinances to allow all of these liquor stores to go into a C4 or C5 zone. So challenge the law. On its face, 2 years is not sufficient. As to each individual place, I know that the former city solicitor had indicated in some of these meetings, well, you folks have been here since 1968. You were on notice since 1971. You already used up your business. I don't think that's the appropriate standard to use. I think the appropriate standard is from the date that the law was passed, not the effective date, and run the 15 years from there. And in any other circumstance, that this board find that 2 years is not sufficient.
Oh, thank you, Mr. Priebus. Okay, what do you have from the city? Ms. Lewis?
Yes. Thank you. Jane Lewis for the mayor and city council. Despite the lengthy housekeeping and the many appellants in this case and the alphabet soup of zoning, this is essentially a straightforward legal issue. And the city's asking the board to make 3 findings today. 1, that amortizations of non-conforming uses, such as section 18701, are a reasonable exercise of the police power. 2, that this ordinance is valid per se. And 3, that it is valid as applied to these appellants. As to the first point, opposing counsel has already acknowledged that this board is bound by Court of Appeals decisions going back to 1957, that these kind of phase-outs of longstanding non-conforming disfavored uses are constitutional. They are not a taking. They're no different, the court said in Grant in 1957, from ordinances prohibiting uses going forward. And the fact that this board cannot overturn all of that precedent and that this is not the appropriate board to bring appropriate forum for that issue just underscores the reality here that this case was brought for the purposes of delay. There are no legitimate claims here. This is a business decision on the part of these appellants to extend their liquor sales and extend their short-term profits at the expense of public safety. As opposing counsel mentioned, all of these suits about amortizations have ended with the court saying the original period was so many years, but it's been held up in litigation for many, many more years. And we have to find that now they've had a constitutional period in which to wind up their businesses. And of course, the appellants logically are hoping here that this will be the same thing, that this will not be the first stop. And by bringing these claims before the board, they've afforded themselves some additional delay for these claims. But it is very clear, as opposing counsel said, that reasonable phase-outs of non-conforming uses are constitutional. They're an appropriate exercise of the police power, and they're not a taking. And all but 3 states agree with Maryland in that holding. Second, the ordinance is valid per se. It's entitled to a presumption of constitutional validity, and it was something that the city council thought through for 4 years. And they determined that liquor outlets in residential areas increase crime. And they determined that 2 years is a standard amortization period for a phase-out of a business with such harmful effects. They determined that based on substantial evidence, including expert reports, testimony from citizens, from public health experts, and even testimony from the liquor store owners who came to these hearings and spoke about how they were the victims of crime. And it's been said before, but it bears repeating, particularly for the appellants who are in the audience today, that this is not about bad licensees. This is not about bad actors. It is about certain uses that attract harmful behavior through no fault of the owners. It is not true to say that you could put in any kind of use and it would attract the same kind of behavior. We may not know why it's the case, but there are many expert studies showing definitively that it is the case, that an increased density of carry-out liquor stores leads to an increase of crime. It's not simply correlative. The expert studies cited in the testimony before the council showed that there was a causal relationship. We don't know why it happens this way. We just know more carry-out liquor stores, always independent of other variables, mean increased crime. And in fact, one of the supplemental exhibits today further refines the Hopkins studies, showing that it's specifically carry-out liquor stores and not taverns that tend to have this effect. So the city council made this determination, and the legislature's determinations deserve deference in this case, unless they are completely nonsensical, and they're not in this case. It is a valid regulation. They also relied on precedents of other phase-outs of harmful uses that was also in the bill file and also in one of the supplemental exhibits. There's a memorandum that summarized for the council similar amortization periods, which were in fact more generous than this one. 18 months seems to have been the standard phase-out for things like check cashing or adult bookstores. So 2 years was a bit more generous for an effect that is arguably more harmful than those uses. Finally, this law is valid as applied to all of these appellants. Some of them acquired their interest in the liquor businesses after the law was enacted, and they have no claim at all because they can't claim to have been harmed or to have a property right taken away that wasn't vested when the law was not in effect. And so those cases are easy to resolve. They are presumed to know what the law is when they go into business. Many of these owners had their businesses since long before 2012. They showed up at a meeting we already discussed in July. Planning sent out letters to liquor store owners. We've submitted as a supplemental exhibit an affidavit from the project manager from the planning department on Transform Baltimore, and a list of liquor stores to whom she sent a letter about the July 12th meeting, and that liquor store representatives initialed at that July 12th meeting. That's in addition to the sign-in sheet. So all of the liquor stores got these letters. Many of them showed up to a meeting to object to these changes. So they had plenty of opportunity. They knew this was coming, and they have been able to amortize their interests over time. As for the group as a whole, none of these appellants have made the kind of evidentiary showing that would allow them to overcome the presumption in favor of this law. This is resolved, these issues are resolved through a balancing test. So the trier of fact has to balance the public interest, which here is very substantial, the public interest in safety, in freedom from crime. They have to balance that against the loss to the businesses and decide whether the loss to a business outweighs the public interest. So what they would have had to show, and didn't show specifically as to any store, is one, the amount they invested specifically in the prohibited use, the sale of liquor, as opposed to investments that can be used for another purpose. As opposing counsel said, these businesses have value, not just as liquor stores, but as corner stores. Many of them, as you can see from the photographs of the interiors of the stores that the inspectors took, sell groceries. Also, you can see that the stores are all located in what public health professionals call food deserts, areas with low car ownership, high rates of poverty, and very little access to fresh food. So there would be a huge value for these neighborhoods in having these stores operate as food stores. They don't have to operate as food stores. That's just one thing they could operate as. There's nothing special in the physical plant of these businesses that's geared towards selling liquor. In fact, you can see some of the drink cases have sodas and waters as well as liquor. The shelves that hold bottles could easily hold cans of soup or groceries. So there's no investment in the physical plant of the stores that's specific to the prohibited use. They would have had to show specifically what their investment was in the stock of liquor, their investment in the business, specific to liquor that couldn't be repurposed for something else. And they would have to give a specific number. What is the amount that is non-recoverable because of this ordinance? Second, they would have had to show why they couldn't have phased out those investments in the time that they had, which in some cases is decades. And opposing counsel is incorrect. The courts can and do consider all the time that you've owned a non-conforming store for the amortization period, not just the 2 years. So why couldn't they have sold off their stock of liquor? Even now, why couldn't they find a legal liquor business and sell their stock of liquor to that business? Why couldn't they, or why didn't they, try and find a business, a convenience store in a commercial zone who wanted a liquor license and try and sell that liquor license to them? There are many things that the owners could have done to try and amortize their investments. That doesn't mean run down the useful life of the investment. And again, the investment here is narrower than appellants would like it to be. It is not the cost of the property. These are 2- and 3-story properties. They could have residences upstairs. They could be used for many things. The properties have value independent of the stores, but specifically their investment in liquor. What did the stores do to try and recoup some of that investment before the 2-year period ran? We don't know. There is no evidence on the record as to what they did, so there's nothing for the board to balance against the public interest here. And even if there were, it would have to be a considerable burden for these owners to overcome the public interest in public safety here. Again, it's a balancing test, so the law does not say that there has to be no harm to the owners, but just that the harm has to be so undue and so unjust that it outweighs what the legislative purpose is here. And of course, there's no evidence here to balance, but it's difficult to imagine that there could be any evidence that would outweigh the public interest here. Of course, some of the owners, we haven't heard from them, but we can infer from the details here that they may have sympathetic stories, that they purchased their businesses that they weren't aware of the law. And they spent a lot of money, and they had expectations that weren't aligned with the legislatures. And that is unfortunate. But an owner's failure to conduct due diligence is not the fault of the city, and it should not overcome the need for this important legislative decision. So, therefore, the board should find that this law is valid as applied to all of the appellants. Finally, we'd like to ask the board to take judicial notice of Maryland Code Section 3-205, which notes that a liquor license issued by the comptroller is not property. And I have copies of that statute here to hand out.
Thanks. Thank you. Council, was that part of the annotated code or Comar?
Alcoholic beverages article.
Thank you.
Yeah, annotated code, alcoholic beverages, section 3-205. Suspension and restrictions over.
And I believe that, contrary to what opposing counsel said, if there were a finding that the ordinance were invalid as applied to any particular appellant here, which there can't be since they have not met their evidentiary burden, they could treat it as an application for a variance of some kind, and that would be possible. There wouldn't even be a need, even if they had shown all these three things, which they haven't, there wouldn't be a need to find the entire law invalid or to throw out the law. But as we said, it should be valid as applied. It is illegal use of the police power, and it is valid per se. Thank you.
Thank you.
Questions? Thank you for the presentation. Mr. Rivas, you have the final word.
Very, very brief. I just want to touch on a couple points that Ms. Lewis made. I just thought of something when she brought in alcoholic beverage article
Yes, sir.
3-205.
Yes, sir.
There is a judicial gloss on that says, let's see, Rosedale Associates Limited Partnership versus Lefta Inc., which coincidentally means money in Greek, says that a liquor license may not be property with regard to the Board of Liquor License Commissioner and the licensees and their conduct, but it is an asset that is freely transferable on the market in every jurisdiction except for Prince George's County. So yeah, first I'd say it's the zoning use that we're here about today, but the Court of Special Appeals has indicated, well, it is a property right. Be that as it may. With regard to the factors that the board would look to, I just want to make 2 points, and that is, because I don't know where you come up with 2 years if you look at all these cases that talk about junkyards and signs and check cashing, that's only a minor provision of a business. Look at the locations. And if you look, I put in the bill history on these ordinances that have, the folks that have luckily gotten new zoning to a C1, and applying the factors as chastised by the law department for the mayor and city council for passing these bills without going through all the factors of the land use article. Well, is there a change in circumstances? Certainly not since 2016. So they had to have gotten it wrong in the beginning. And one of those factors, and one of the facts that they point out in there is, look at the location. Okay, we're not talking about Eddie's of Roland Park. And I'm not saying anything bad about these neighborhoods, because they're good folks that live in old neighborhoods, and they're good business owners that own old businesses. But look at the area, and if you go for blocks and blocks and blocks with a vacant house, you have, one of the factors that you would look to would be the location. And is this property affecting that neighborhood? No, it's bringing it up. The other issue is that I wanted to raise was public safety. If I go down to South Baltimore to Harris Teeter, do I really feel unsafe because they have a liquor department? Now, because of Maryland law, you can't have liquor stores in a grocery store. We have this machination where you go through this other door and whatnot, but go to Harris Teeter or go to Wegmans in Virginia. I remember as a kid coming home from college and my mom telling me on a Sunday, I was 18, we're having folks over. Go down and get some liquor. And I, Mom, I went to the Giant. I can't find any beer here. What the heck's going on? Because I went to school in Tennessee, and I didn't realize it. But your grocery stores, your Kroger's, whatever, they sell beer and wine. I don't know how you look at this study and say, well, if you sell beer and wine for carryout, you're 47% more likely to be a victim of a violent crime. It's not that. It's the neighborhood. It's the policing. It's the activity, the relationship between the police and the neighbors and the business owners. That's what makes a difference, not get rid of the liquor store. Okay, now we have another vacant building. And that's what the bills are saying. We're going to rezone this person because we're just going to end up with another vacant building. Yes, we could sell groceries, and no, we would go broke doing it because your profit is from the liquor stores. All of my clients, they hope to cater to their customers and increase their revenues, and if it's grocery items that do it, they're absolutely going to do it, but they're not going to stay viable economically by getting rid of the alcohol. It's the thing that's keeping a lot of these people afloat. For all that said, I hope this law goes away. Thank you.
Thank you, Mr. Rivas. Appreciate your presentation. And, we're waiting on some additional testimony.
Are we?
From the councilman?
Yes.
We got a letter.
Got it.
So,
Just for the record, we received a letter from Councilwoman Mary Pat Clark, which I will just read into the record, if that's not, there's no objection to any of the parties. Dear Chairman and members of the board, on behalf of myself and the Coldstream Homestead Montebello Community Corporation and its 3 appellant locations, I am present to support the city's efforts to uphold the validity of the termination of alcohol sales for, it looks like 4 properties, 2643 Cecil Avenue, 2701 Hugo Avenue, 1601 East 29th Street, and 1700 Cliftview Avenue. She goes on to write that as a member of the she was a member of City Council during the transform process. In that process, hearings were well attended. The presence of alcohol sales in these areas in the midst of otherwise residential properties too often represent disruptions to safety and occasions of loitering and even drug trafficking. So late in the process, it is frustrating that so many establishments have ignored this termination and bought time with this appeal while still selling alcohol. We ask this board to reject this appeal.
Thank you. And does that conclude the record on this matter? We will. Thank you all for your presentation.
Thank you.
Thank you.
I still have to do the paper copies of the exhibits.
Thank you, Mr. Rivas.
Did you all want to deliberate and vote today? Did you want to deliberate a little bit and see where you're at and postpone to next year? What are you feeling like? So before I start shuffling,
Kindergarten.
I want to see what y'all were.
Crazy.
Do you want to deliberate
Absolutely
now
crazy.
or later?
Additional